Bismillahirrahmanirrahim. Assalamu alaikum, dear viewers. Myself Shafad Khan, and today I am here to discuss a very important topic, that is what goes wrong with the meaning, legislation, and functioning of mediation in Pakistan. This video provides a detailed overview of how mediation is legally structured, practically implemented, and what challenges it faces in Pakistan. And in the end of this lecture, inshallah, you will have a clear understanding of its key concepts. So let's move towards the introduction. The introduction mainly focuses on three main aspects of mediation in Pakistan. The very first one is what is its legal meaning. The second one is how it is treated in legislation, and the third one is how does it actually function in practice. And inshallah, we will talk about the key challenges like confusion in terminologies, scattered and inconsistent laws, and lack of practical implementation. And in the end, inshallah, we will discuss the practical solution to improve the situation in Pakistan. So first of all, let's talk about the meaning of mediation. Mediation is supposed to be a peaceful way of resolving disputes where a neutral third person, known as mediator, help the parties to talk and settle their differences or disputes. But in Pakistan, the term mediation is often mixed up with other terminologies like conciliation, arbitration, and negotiation, etc. Different terms are used in our laws like saleh, salis, musla, etc., without clearly explaining what they mean actually. So overall, the term mediation in Pakistan is used in very general sense without any clear legal boundaries. This was the meaning of mediation. Now let's talk about the legal sources of mediation. So here is some general laws about the mediation. One major legal provision about the mediation in Pakistan is Section 89A of the Code of Civil Procedure 1908. This section, Section 89A of CPC, allows courts to refer disputes to mediation or conciliation, but only with the consent of the parties. However, the problem is that this law is not mandatory, so courts often do not apply it. Also, there is no separate mediation law in Pakistan, so the whole process lacks clarity. In the legal sources of mediation, here is some specific laws, like the Family Court Act 1964, which requires court to try reconciliation between the spouses. And if it is before the trial, this is called a facilitative mediation, and if it is after the trial, it becomes evaluative mediation. Or we can say that mediation have two types: facilitative mediation and evaluative mediation. Another example is the Small Claim and Minor Offences Ordinance 2002, which introduced the term salis. Salis means a neutral third person who can mediate, conciliate, or arbitrate between the disputed parties. Another one is local government laws. Local government laws in all provinces have also used terms like Muslahat Anjaman or mediation boards to resolve small civil or criminal issues outside the courts. Along with this, we have some area-specific laws about mediation. So let's talk about area-specific laws. The most important one is the Shari Nizam Adal Regulation 2009, which applies to the Malakand region and some parts of the Kohistan too. This regulation introduced the term Muslia, which means a peacemaker, but again the term is not clearly defined. Interestingly, the Muslia can act as a mediator, conciliator, and even arbitrator, depending upon the case. This creates more confusion because their role is not clearly set in law or in practice. Means it creating some of an issue. Now let's move toward the challenges. So this slide is about the challenges in practicing the mediation in Pakistan. Now let's look at why mediation is not working well in Pakistan. The very first reason is that ADR laws are not mandatory, so courts often ignore them. The second one is people unawareness. most of the people is unaware of mediation, and they don't know what mediation is and what ADR method is. Also the lawyers opposes it. Also the lawyer opposes it, thinking that it reduces their fees and a source of income. Similarly, the judges prefer formal litigation because judges feel safer following regulations, procedures instead of trying informal settlement. And there is no consistency in terms like muslia and sales, and these are used without any explanation. Also, mediators don't get paid, so that they are not motivated, and the judges worries that mediation will delay case statistics, affecting their performance reviews. Now let's talk about the poor functioning of the mediation in Pakistan. Let's see the actual data. Like as in 2016, the courts in multiple districts referred 0 points, 0% of the cases to mediation under the section 89A of CPC. Even in family courts where reconciliation is mandatory, the success rate is just 4.3%. And also in some areas, especially in Pashtun speaking regions, there is more resistance to mediation due to the cultural reasons. So overall mediation is rarely used even when the law encourages it. So this was all about the poor functioning and the challenges of mediation. And now let's move toward the sum of its success ratio too. Despite their poor functioning, we have some success ratio too. Like in Khyber Pakhtunkhwa, dispute resolution councils have resolved over 6,000 cases. The Judicial Academy in Peshawar has trained judges and lawyers in mediation, and some family cases referred to them have been settled peacefully. So basically, with the right support, mediation can work. Now let's move toward the reforms. To improve the situation, first of all, we have to make clear, unified the mediation laws in Pakistan, and then simply and define the legal terms like salis and muslia, and also make the ADR as a mandatory first step before the trial. Along with this, government have to train all the stakeholders like judges, lawyers, and social workers. Also, pay mediators and give rewards to judges who use ADR, and don't count mediation time as a court delay. Start civil mobile courts to increase access, and add training on the ethics and conduct of for judges. These reforms are needed for the better functioning of mediation in Pakistan. Let's move toward the conclusion. In conclusion, mediation in Pakistan is confused in definition, weak in law, and poor in practice. But with the better laws, proper training, and support from the judiciary, it can become a powerful tool for fast and fair justice. So, dear viewers, that was all about the mediation, its challenges, practices, issues, and its reforms. So, if you have any question regarding this lecture, please feel free to ask me in the comment section. Inshallah, I will assist you as soon as possible. Thank you. Thank you so much for watching this video, and don't forget to like, share, and comment.